The International Criminal Court is now in session.
Thank you to the bench clerk. Good morning, good afternoon, good evening, wherever you may be in the world at this moment, and welcome to another hearing in the quarterfinal rounds. The case is Prosecutor versus Gravis, and we'll hear today again arguments on an admissibility and jurisdiction challenge of the defense. My name is Maria O'Leary. I will be the presiding judge in this session, and I am joined by two esteemed colleagues who I will give the floor now to introduce themselves.
Good morning, I'm Roger Clark. I'm checking in from Philadelphia. I taught for many years international law, international criminal law at Rutgers State University of New Jersey. Delighted to be here with this group.
Good day, my name is Nicolai Bülte. I'm based in Marburg, Germany, and I'm very much forward to looking into hearing the presentations.
Thank you very much, panel. I will now hand over to the prosecution and the defense to give appearances in the proceedings, and if you can, indicate how you allocate your time for your submissions today. Prosecution, your appearances?
Good morning, good afternoon, good evening, Madam President, Your Honors. My name is Özge Karsu. Today, I'm representing the OTP, the Office of the Prosecutor, with my co-counselor, Mr. Ashula. Today, first, Mr. Ashula will cover the issue of admissibility. He will talk for 8.5 minutes. Then I will cover the issues of jurisdiction and superior responsibility of Mr. Gravus, and I will talk for 16.5 minutes. And we reserve 5 minutes for rebuttal. Thank you.
Thank you very much, prosecution. Defense appearances?
Good morning, good afternoon, good evening. My name is Kichanga Mulandi, and I will be addressing the issues of jurisdiction and admissibility in 15 minutes. And my co-counsel, Shamia Muchasia, will be addressing the issues of command responsibility in 10 minutes. We reserve our 5 minutes for rebuttals.
Thank you very much to the parties. Prosecution, you have the floor.
Madam President, Your Honors, may it please the court. My name is Mohammed Dizderevich Ashula, and I will be pleading on behalf of Office of the Prosecutor, the OTP. Today, we will show on reasonable grounds that the case is admissible, the court has jurisdiction, and Mr. Gravus is criminally responsible. I will focus on admissibility and speak for 8.5 minutes. My co-counsel, Ms. Karsu, will cover the other issues. We reserve 5 minutes for the rebuttal. The present case involves Castarians who are victims of genocide. Castarians were oppressed by authoritarian governments for generations. They only tried to take their freedoms back. They were labeled as terrorists. They were killed, assaulted, were forced to live under the terrible conditions by the military regime. Justice for the victims and for Mr. Gravus cannot be achieved by a military court that established by a putschist general against another one. As confirmed by this chamber in the decision on admissibility challenge in Saif al-Islam Gaddafi case, paragraph 32, the burden of proof in admissibility lies with the challenging party, the defense. They have to demonstrate that Hanatun is willing and able to conduct an investigation. Most importantly, as confirmed by that decision, as well as in the Kenya admissibility decision, paragraph 61, by ICC Appeals Chamber, the evidentiary standards in this particular issue is evidence of a sufficient degree of specificity and probative value. Under Article 17 of the Rome Statute, for a case to be admissible, the case must be of sufficient gravity and the principle of complementarity must be satisfied. Now, I will turn to the first issue. The case is of sufficient gravity as required by the Article 17(1)(d) of the Rome Statute. The gravity of the case is evidenced by the Security Council's referral of the situation in Hanot. It is also supported by other elements, such as the leadership rank for perpetrators, the extent of damage caused, in particular, the harm caused to victims and their families, the number of victims, as well as other qualitative factors, as indicated in Abu Garda case. To give a glimpse of the facts, 200 Castilian men were shot dead when they resisted arrest, and 150 female Castilians, among them girls aged between 13 to 24, were arrested. 86 male companions were shot in the head. The girls were taken by the SPG to different stations where they were forced to cook and provide sexual services so that the SPG officers would not kill them. Police department forced all local businesses to close and warned them not to reopen. All roads to Castelia were blocked, and this blockade caused a famine throughout the Castelia. Even the images from the social media, the dead bodies of women and children on the streets demonstrate that there are reasonable grounds to believe that the case is of sufficient gravity. In light of these facts, the fact of famine increases the gravity from a qualitative perspective. Therefore, there are reasonable grounds to believe that the gravity threshold under Article 17(1)(d) of the Rome Statute is met in the present case. Now, I will turn to the second issue, namely that the principle of complementarity has been satisfied due to Hanotun being unwilling and unable to genuinely carrying out the investigation or prosecution.
Counsel, I have a question about the burden of proof here. You're arguing that the defense carries the burden of persuading us on the admissibility issue. Could you tell me how I can reconcile that with Article 67(1)(I), which relates to the rights of the accused? It says that the accused is entitled not to have imposed on him or her any reversal of the burden of proof or any onus of rebuttal. Where is Article 67(1)(I) overridden by something in Article 17 or 19, perhaps? Where does your law come from?
Your Honor, as confirmed by this chamber in the decision on admissibility challenge in Saif al-Islam Gaddafi case, when the admissibility is challenging by the opposing party, the defense.
Where did they get their law from? Where did they find that in the statute?
Your Honor, I can answer your question as according to article that you mentioned, according to the Rome Statute, it is clear that the burden of proof lies with the prosecution. However, as challenging party in this present case, the burden of proof lies with the defense due to the fact that to case law.
Thank you, counsel.
According to paragraph 10 of the Rome Statute's preamble, it is clear to understand that the ICC is a court of complementarity. The ICC does not seek to replace a state's judicial functions. Rather, it complements them. It only acts when the state is unwilling or unable genuinely to carry out the investigation or prosecution. In other words, complementarity is a crucial notion which plays an over-serious role in international criminal law, especially in terms of jurisdiction issues. It is easily seen that the notion of complementarity represents the balancing act between the ICC and the state party's jurisdiction. A case is admissible if the state is unwilling or unable genuinely to carry out the investigation or prosecution. The appeals chamber defines the terms unwilling and unable as the state having jurisdiction and has not done the investigation with mere investigative steps. There should be an investigation by the relevant state about the relevant case in order to conclude that the state is willing to carry out the investigation and consider the quality or seriousness of the investigation. In the present case, Hanatun was unable to investigate or prosecute since the military intervention harmfully affected the governmental and judicial system twice in 6 years. Also, first coup was held by Mr. Gravus. After 6 years, second coup took place. It is important to state that the conflict in Kasteria drove near to civil war. Accordingly, there is neither judicial independence nor such an institutional ability for such an investigation. Also, it is important to state that the investigation or prosecution is not sufficient to challenge admissibility. They should also be genuine. In order to determine an investigation as genuine, the state should use all the legal means as it disposes in the conduct. In the present case, Hanatun was not acting genuinely. The military court was established after the concrete and continuous pressure from both international and national human rights organizations. It is not sufficient merely to assert that the investigations are ongoing. Indeed, there is no single information or evidence in the case file which shows that the military court actually, in fact, started the investigation. The ICC, in the present case, is required to take action, since the national criminal jurisdiction is unable and unwilling to have an effective prosecution. Unless I have further assistance to this pre-trial chamber, this concludes my submission. Now I will yield the floor to my co-counselor, Ms. Kars. Thank you.
Thank you. I actually have a question before you go, counsel, and it's related to the unwillingness and the unable or inability. You've said that they have not started investigations yet that you know of, but as far as we have from the facts here, it sounds like they're going to be concluding next month in August. Is this something that the chamber should take into consideration, that within a month's time, we may have further information on the status of these investigations that could factor in towards using that complementarity principle and allowing the domestic jurisdiction to try the case?
Madam President, no, it does not. It doesn't show that it is starting. It is telling the time that military court will start their processes. So as considering duration of time, we cannot able to state that.
Thanks. We can move on to co-counsel unless there's other questions from the bench.
Madam President, Your Honors, may it please the court. My name is Özge Karsu, and today I'm pleading on behalf of the OTP. Today's case involves the destruction of the very essential foundations of the life of Castrians. It involves hundreds of victims who face atrocities that shocked and disappointed the notions of humanity. It involves the need for this court to put an end to impunity for the perpetrators of the crime of crimes, the crime of genocide. Today, before the pre-trial chamber, I will show that there are reasonable grounds to believe that the court has jurisdiction and Mr. Gravus is criminally responsible. Now I will start with the second issue, jurisdiction. The situation in Hanatun was referred to the OTP by the United Nations Security Council as per Article 13, paragraph B of the Rome Statute. Accordingly, there are two preconditions for jurisdiction in the present case: temporal jurisdiction and subject matter jurisdiction. I will start with temporal jurisdiction. Under Article 11, paragraph 1 of the Rome Statute, the court's jurisdiction is limited to the crimes that were committed after the entry into force of the statute. The court has temporal jurisdiction in the present case, since the acts were conducted after 1 July 2002. Now I will move to subject matter jurisdiction, and I will present my arguments in three main parts: the material elements, the mental elements, and the contextual element of the crime of genocide. Starting with the material elements, the acts in the present case include conduct of killing and inflicting certain conditions of life on Castrians calculated to bring about their physical destruction. I would like to remind this pre-trial chamber about the acts directed against the Castrians. During the house arrests, 200 Castrian men were shot to death. 86 Castrians were shot in the head at the airport, and 150 female Castrians were arrested. The girls, aged between 13 to 24, were taken by the SPG to different stations where they were forced to provide sexual services and cook. Further, there was a blockade which resulted in famine and caused a significant risk to their physical existence. These acts were conducted by the security forces, the NDS, SPG, and the police department, and the target was Castrians, which constitute an ethnic and religious group. A case trial chamber defines the term ethnic group as a group whose members share a common language or culture, and the religious group as a group whose members share the same religion, denomination, or mode of worship. Castrians share a common language called Otati, and they have the same worship as they believe in a god called Otsari. Further, as confirmed by the Christ's trial judgment, a group's characteristics must be identified within the social historical context. As stated in case facts, in paragraph 4 and onwards, Castrians, as an ethnic minority, have been oppressed for more than 100 years, and even they were resettled in the region of Casteria, a province in the middle of Anatun. Even though clarification 1 states that the term Casterians refer both to ethnic minority and the general population, the target in the present case was Casterians as an ethnic and religious group. Now I will move to the Menswear requirement of the crime of genocide. There was a specific intent to destroy Casterians in whole or in part. As confirmed in the Bilagojevich and Jovic trial and Jovic judgment, excuse me, Your Honors, specific intent of the subordinates shall be demonstrated for subject matter jurisdiction. In the present case, the subordinates, the security forces, had the specific intent to destroy Castrians. As stated in the elements of crimes, existence of intent and knowledge can be inferred from relevant facts and circumstances. The ICTY states several factors which can show the existence of specific intent. These include the existence of a plan or policy, the perpetration of acts systematically directed against the same population, the scale of atrocities, the repetition of the acts, and systemic targeting. Now, I would like to direct this pre-trial chamber to paragraphs 13 and 15 of the case facts, which indicate the specific intent of the security forces. First, as can be seen in paragraph 13, during the searches, the SPG forces were calling, and I quote, Castrians are cancer, end of quote. Second, the NDS released Mr. X when they recognized that he was not a Castrian, but belonged to Hanu ethnicity. But at the very same night, they killed 200 Castrian men. And third, as stated in paragraph 15 of the case facts, the police department conducted a blockade in Casteria, which is predominantly home to ethnic Casterians. These facts demonstrate that the acts were directed against the Casterians because of their group identity, with the intent to destroy them in whole or in part. Lastly, I will talk about the contextual element of the crime of genocide, the existence of a manifest pattern of similar conduct. Elements of crimes, which the court applies in the first place, require such an element. The acts in the present case took part in the context of a manifest pattern of similar conduct. The oppression against Casterians started more than 100 years ago, and then it continued with reducing the federal payments and preventing Casterians from taking positions in the government. And then the counterterrorism campaign gave power and authority to the security forces to destroy Castrians. It directly named Castrians as supporters of terrorism, and it also stated that the campaign has long-term purposes. Accordingly, the threat against Casterians were concrete and real. Considering all these facts and evidence, the OTP submits that there are reasonable grounds to believe that the court has jurisdiction. Madam President, Your Honors, I will now move to the third and last issue, individual criminal responsibility of Mr. Gravus. In the Bemba case, the pretrial chamber stated that in order to prove criminal responsibility within the meaning of Article 28, paragraph A of the Rome Statute, 5 elements must be fulfilled. Individual criminal responsibility of Mr. Gravus will be examined in these 5 consecutive parts. First, the OTP invokes Article 28, paragraph A of the Rome Statute, since Mr. Gravus is a military commander. The Chamber defines the term military commander as a category of persons who are formally or legally appointed to carry out a military commanding function. This also includes superiors who do not exclusively perform a military function. Mr. Gravus was the president and commander-in-chief of the armed and security forces since August 2016, and he was holding the status during the commission of the crime. I will now move to the second element. Mr. Gravus had effective authority and control over the subordinates. Effective authority requires the material ability to prevent or repress the crimes, or the ability to submit the matter to competent authorities. The court determined several criteria to indicate the existence of control on the basis of evidence. The official position, the power to issue orders, and the capacity to ensure compliance are indicators of effective control. Mr. Gravus was the president and commander-in-chief. There was a hierarchical relationship between Mr. Gravus and the security forces. As stated in the orders of the counterterrorism campaign, in case fact paragraph 11, subparagraph E, heads of all 3 security divisions report personally to the president. And as shown in Exhibit 1, there was a direct communication between Ms. Jolie, head of the NDS, and Mr. Gravus. In this text message, Mr. Gravus said, and I quote, "Please report to me any security-related threats," end of quote. This demonstrates that there is constant communication between them. Taking and implementing orders within such a reporting and communication system demonstrates effective authority and control of Mr. Gravus. I will now...
Can I stop you right there? Is one text exchange sufficient enough, especially one as brief as Exhibit 1 here? Is that sufficient enough to show a reporting chain and sufficient enough to show that there was ongoing communication, as you just mentioned?
Madam President, we would like to clarify that the evidentiary standard in the present case is reasonable grounds, and at this stage we can use circumstantial evidence to demonstrate facts. So accordingly, Exhibit 1 combined with the other case facts that I mentioned, including paragraph 11 of the case facts, the counterterrorism campaign, we submit that this is sufficient to establish there are reasonable grounds regarding our argument.
Just on the reporting specifically, what is the circumstantial evidence that you're relying on besides Exhibit 1 to show there is a chain that gives him that effective control?
Exhibit 1 combined with paragraph 11, Madam President. Paragraph 11 states the orders of the counterterrorism campaign. And this order states that heads of all 3 security divisions will report personally to the president. And also it states that there is a hierarchical relationship between the security forces and Mr. Gravus as the president. And also Mr. Gravus's position as the president and commander-in-chief, who controls the entire army, security forces, and all 3 branches of the government, is a strong indicator in the present case. I will now move to the third element. Mr. Gravus knew or should have known that the forces were committing or about to commit the crime of genocide. As confirmed by this court in the Bemba case, the suspect's knowledge again can be obtained by circumstantial evidence. The court stated that there are several factors which indicate the existence of knowledge. These include the number, type, and scope of the acts, the time the acts occurred, the type and number of forces involved, the commander's position, and the means of communication. In the present case, the position of Mr. Gravus and the communication system between him and the security forces are important indicators of knowledge. Second, all 3 security divisions were involved, and the acts were widespread and systemic in nature. Third, the acts did not occur within a few days. The acts that are mentioned between paragraphs 12 to 15 were occurred in a full of 2 months. In fact, Even the international community, including many states, the European Union, and the United Nations Security Council were aware of the situation. And as stated in paragraph 15, there were even images on social media. Considering all these, it is illogical to claim that the president and commander-in-chief of a country lacks actual knowledge. I will now move to the fourth element. Mr. Gravus failed to take the necessary and reasonable measures to prevent or repress the crime. Article 28 of the Rome Statute does not define the specific measures, but this court made such a determination. Accordingly, in order to prevent the commission of the crime, the superior is responsible to secure reports that military actions were carried out in accordance with international law, or to take disciplinary measures to prevent the commission of atrocities. And regarding the duty to repress, Your Honor, and regarding the duty to repress the commission of the crime, the superior is responsible to stop the ongoing crimes and to punish the subordinates. Mr. Gravus did not take any measure to prevent or repress the commission of the crime. In the case facts, there is no single evidence which can demonstrate the opposite. Mr. Gravus even called the decision of the Security Council a conspiracy against the national security of Anatun, but he did not take any kind of measures. And lastly, the crimes committed by the subordinates were resulted from Mr. Gravus's failure to exercise control. Even though Mr. Gravus had an effective authority and control over the subordinates, he failed to control their acts, and this increased the commission of the crime. For the foregoing reasons, the OTP respectfully urges this court to find that there are reasonable grounds to believe that the court has jurisdiction, the case is admissible, and Mr. Gravus is criminally responsible. Terminating the prosecution based on misplaced legal arguments, rhetorics, and distorted facts will not only harm justice, but it will also threaten international peace and security. At the 27th anniversary of the Srebrenica genocide, we pay tribute to all victims. This chamber should join the OTP and the United Nations Security Council in their commitment to international criminal justice, peace, and security. Never again. Not in Auschwitz, not in Srebrenica, not in Kasteria. Thank you.
Thank you. Are there any questions from the panel?
So I just have a small question, Council. I thought from the statement of facts that you were arguing the alternative that Article 28A and 28B applied to the defendant. Your argument just went to Article 28A. Could you just explain where you're going with that, or not going, as the case may be?
Yes, Your Honor. As you stated, we are basing our arguments in 28 paragraph A of the Rome Statute. Right. And just to clarify, I see that my time is up, but can I answer the question? Thank you. We are invoking now Article 28, paragraph A of the Rome Statute because Mr. Gravus is a military commander. He was the commander-in-chief of the armed and security forces. That's the reason why we are basing our arguments in Article 28, paragraph A of the Rome Statute, not B.
Right.
Thank you.
Thank you, Counsel.
Thank you, prosecution. And we can now give the floor to the defense.
Thank you, Your Honor. May it please the court. Judge President of the court, Your Honors, justice hurried could be justice buried. The case before you today is one of rushed proceedings that have wrongfully resulted in the wrong man being brought before this court of law today. The defense will illustrate that for the following reasons, Mr. Gravus cannot reasonably be held criminally liable for the crime of genocide. Firstly, the accused targeted members of the CNF and not the Castilian ethnicity, hence negating special intent under Article 6 of the Rome Statute. Secondly, the target of the conduct was not an ethnic nor a national group, hence negating the requirement for the conduct to be directed towards a protected group under Article 6 of the Rome Statute. And thirdly, that the case cannot be received by this court at this given time, given that it would be in breach of the principle of complementarity. I will take a total of 15 minutes addressing the first three issues, and my co-counsel will take a total of 10 minutes addressing the issue of whether Mr. Gravas can reasonably be held criminally liable pursuant to Article 22 of the Rome Statute. The defense accepts that the requirements for temporal jurisdiction under Article 11, as well as jurisdiction ration loci and persona under Article 12.2 respectively are met. The issue in this case is as regards to the subject matter jurisdiction of the crime of genocide. Now, it would be sufficient for the defense to disprove either one of the specific elements or contextual elements are not met to negate jurisdiction. We submit that the accused targeted members of the CNF and its supporters and not the Castilian ethnicity, hence negating special intent. Now, the case of the prosecutor versus Bashir in the decision on the application for an arrest warrant of 4th March 2009, in paragraph 139, the court held that the subjective element of special intent is a key constitutive element towards proving a genocidal intent. Now, Your Honor, the same in another case of the prosecutor versus Kaishema in the ICTR, it was held that genocidal intent can be inferred from answering the question, who was the target of the conduct? We submit that the target of the conduct was the CNF as well as its Castilian supporters. The honorable judges have noted that the prosecution has linked the case at hand towards the Rwandan genocide. However, this court must disjunctively test the case's test for the following reasons. In the case of the prosecutor versus Akayesu, in the decision of the trial chamber in the ICTR, it was held that the fact that Tutsis were attacked on account of their original home being in Abyssinia showed that there was genocidal intent. However, from the facts at hand in paragraph 4, we do see that it is clear that the Castilians have always lived in Hanatu. Further, in the same case, which the prosecutor has relied on, we do see that Hutus and Tutsis were systematically separated on the basis of the identification cards, which was indicated as per their ethnicity. Now, Your Honor, in the facts in paragraph 11E, we do see that the command orders were to separate individuals based off their membership and support of the CNF, which is branded a terrorist organization. And this reality is confirmed when the NDS went into Luz and Luzari searching for members of the CNF. Now, this is of particular importance given the fact that Luz and Luzari are the most populated cities in the region of Castilla, which it is home to many Castilians. Now, Your Honor, given this, we do see that in the same case of prosecutor versus Akayesu, it was held that the fact that a military letter was disseminated that highlighted the primary enemies as Tutsis and the primary enemy supporters as Tutsi supporters and dissatisfied Hutus shows that the target of the conduct was the Tutsi ethnicity. However, from the campaign objectives in paragraph 11, we do see that the written orders allude to the CNF terrorists as the primary enemies and their Castilian supporters as the primary enemy supporters. Now, as pertains to the prosecutor's submissions that subordinates chanting Castilians are a cancer is indicative of Mr. Gravas's genocidal intent, we would like to guide the court to the case of the prosecutor versus Bashir in the trial chamber 1. Yes, Your Honor.
Could you clarify for the court, in cases of command responsibility, who has to have genocidal intent?
Thank you, Your Honor. Your Honor, the case of the prosecutor versus Bashir in the trial chamber 1 noted that intent of the mid-level superiors and subordinates is irrelevant in determining the intent of the accused. And given this, we would like to draw a similar analogy and submit that Mr. Gravas lacked genocidal intent. Consequently, Your Honor, this brings me to my next submission, that the conduct alleged cannot constitute genocide pursuant to Article 6 of the statute, given that it was not targeted towards the protected group. We submit that the CNF was the target of the campaign as submitted previously, and consequently, the CNF is not an ethnic nor a religious group as erroneously submitted by the prosecutor. When assessing whether a group can qualify as an ethnic group, we do see the objective approach and subjective approach are considered. Now, the Al-Bashir pre-trial chamber acknowledged in the decision on the application for an arrest warrant that there is no preference. However, defense advocates for a mixed approach are seen in the ICTY case of the prosecutor versus Kirstich in the trial chamber. And we submit that on both grounds, the CNF fails to qualify as either. On the objective approach, we do see that it is imperative to distinguish between the Castilian ethnicity and the CNF as a group. From the clarification submitted to this court, we do see that Castilians refers to members born into the Castilian ethnicity, while the CNF refers to individuals who freely and willfully decide to join the group. Now, the same case of the prosecutor versus Akayesu in the trial chamber decision held that ethnic groups are distinguished by common language or culture, and the al-Bashir pre-trial chamber decision on the application for an arrest warrant acknowledged this and made it a cumulative test, adding tribal links to the land as a requirement. Now, from the facts of the case at hand, we do see in paragraph 7 that the CNF was created on 20th September of 2016 and therefore lacked any specific tribal links to the land. And further, Your Honor, we do see that it is the Castilian ethnicity that has tribal links to the land and not the CNF as a group. Further, Your Honor, we do see in paragraph 5, we're told that Castilians are the ones who speak Otati, and the CNF has not attempted to distinguish themselves by having their own separate language and therefore cannot objectively qualify as an ethnicity. On the subjective approach, we do see that the al-Bashir decision on the application for an arrest warrant in paragraph 25 held that the fact that the Far, Mazalit, and Zagwa tribes were referred to with the derogatory term Nuba, meaning black, showed that they were subjectively seen as an ethnicity. From the facts at hand in paragraph 10, we do see Mr. Gravas refers to members of the CNF and their Castilian supporters as a cancer and not the Castilian ethnicity as a whole. Further, when it comes to the Bashir decision on the decision for the application of an arrest warrant, we do see that the fact that the Far, Mazalit, and Zagwa spoke a distinct language separate from Arabic and that they had a distinct land grant system as well as a social structure show that they were an ethnicity. Now, from paragraph 7 of the facts, the CNF had a military wing. And Your Honor, it is rightfully stated that they were a terrorist organization. Now, Your Honor, the Special Tribunal of Lebanon's Interlocutory Decision 11 on the applicable law states that terrorist organizations are groups that bind together to coerce a national or international authority to act or refrain from taking some action. From paragraph 7, we do see that a military wing was established by the CNF and it was unconstitutional. Further, we do see this military wing was established to coerce Mr. Gravas' government to increase funding to the region of Castilla, and therefore the CNF is, in fact, a terrorist organization. Now, Your Honor, the Bosnia and Herzegovina versus Yugoslavia ICJ decision of 1993 held that genocide is international customary law. Article 22.2 of the statute stipulates that crimes shall be strictly construed and not extended by analogy. Article 6 lists an exhaustive list of protected groups, and terrorist organizations are not included in this list. And therefore, it would be wrongful for this court and in breach of the principle of legality to extend the crime of genocide to the CNF. Your Honor, this brings me to my next submission, that this case cannot be received by this court, given that it would be in breach of the principle of complementarity under Article 17 of the statute. Now, Your Honor, under Article 17(1)(a), it is stipulated that where a case is being investigated, then the court must turn towards assessing inability or unwillingness. Now, as pertains to the investigation of the case, we do see that the appeals chamber in the case of the prosecutor versus Simon Bagbo stated that to prove investigations are ongoing, the court must be satisfied that steps are being taken to ascertain the criminal responsibility of the individual and the alleged conduct. Now, the defense submits that from paragraph 18, it is clear that a military court was established on 10th December of 2021. Further, Your Honor, it is clear that the admissibility challenge came into place on June of 2022, meaning that there has been a period of 8 months elapsed, which is sufficient, Your Honor, and which is not an unjustified delay. Further, Your Honor, we do see—
Counsel, I have a question. I asked your opponent about Article 67, paragraph 1, subparagraph I earlier on. Are you conceding that you carry the burden of proof on this issue of admissibility?
Thank you for your question, Your Honor. And this is in fact a fundamental question that has drawn a lot of attention in the international criminal law world. Now, Your Honor, it was held in the case of the prosecutor versus Mbaroshimana that a reading of Article 19 conjunctively with Article 58 states that we do indeed carry the burden of proof as pertains to admissibility challenges and jurisdiction challenges. Does that answer Your Honor's question sufficiently?
Thank you. So you're conceding the point is the answer. You accept that the binding authority on this point and that we should not reconsider that issue on the basis that the previous court got it wrong, dead wrong. Mm-hmm.
Your Honor, we do concede that we carry the burden of proof in this case. And consequently, Your Honor, we do see that the Simon Bagbo case stated that investigations and prosecutorial activities are to be considered from the time of the admissibility challenge, which occurred on June of 2022. And therefore, Your Honor, there have been investigations, given that the court was formed on December.
I understand your answer. Thank you, counsel.
Yes, Your Honor. Thank you. Moving on, Your Honor, we do see further that from the case at hand, the military tribunal has a clearly defined role, and the case and the test outlined in the prosecutor versus Simon Bagbo is fulfilled. Now, Your Honor, we do see that the ambit of the military court and the investigations do in fact pertain to Mr. Gravers. And we see this given that we are told that the investigations are from November of 2015, which is when Mr. Gravers assumed office via coup d'etat. Further, Your Honor, these investigations are progressive, given that we're told that they're to end on July of 2022. Consequently, Your Honor, this takes us to examining inability. As pertains to inability, the court is to examine whether there has been a total or substantial collapse of the national judicial system, which renders the national authorities unable to investigate or prosecute. Now, Your Honor, we do see that in the situation concerning Libya, more specifically in the Gaddafi appeals chamber decision concerning admissibility, we are told that here we are to consider whether the authorities are able to perform their basic judicial functions. And these basic judicial functions include apprehension of suspects, as well as investigations in the conflict region. Your Honor, we are told from the facts that the authorities have been able to successfully apprehend Mr. Gravers, showing that they are in fact able to properly execute their duties. Further, Your Honor, we are told from the facts at hand that these investigations pertain to the conflict regions, which shows that they do in fact cover the substance of the case at hand. As pertains to unwillingness, Your Honor, we do see that here in the same decision, it was held that we are to consider if the proceedings are taken to shield the accused, if there has been an unjustified delay in the proceedings, or if the proceedings have not been conducted impartially. Your Honor, we do see that the investigations are at their premature stage, and therefore, Your Honor, we do see that there is no sign that these investigations are being taken to shield the accused. Further, in the clarification submitted to this court, more specifically clarification number 3, we are told that the military officials that recommended the release of Mr. Gravers have no impact on the military court. Your Honor, as pertains to unjustified delay, we do see that the Simon Bagbo Appeals Chamber stated that a period of 18 months is too long. Your Honor, in the case at hand, the period elapsed is only 8 months, meaning that the Republic of Anatun is still within their time frame to conduct proceedings, given that they have stated that the investigations will conclude in the next month of August of 2022. Consequently, Your Honor, we urge you to reject the prosecution's arguments and speculative proceedings and wait to see any signs of inability or unwillingness before prematurely exercising admissibility and violating the principle of complementarity. With that, Your Honor, I would like to yield the floor to my co-counsel, Mr. Shamia Muchesia, unless I have any further questions.
No questions from the bench.
Thank you, Your Honor.
Please proceed.
Good afternoon, Your Excellencies, and I'd like to begin by thanking you for this sublime opportunity to practice before this honorable chamber. But before I begin, please permit me to characterize the pleadings that are before you. The man that stands before this court is a man that is betrayed, deceived, and later on impeached by his own forces. We ask that the eyes of this court go far beyond the unbacked claims and presumption by the prosecution and deliver justice where justice is due. May it please this court, my name is Shamia Muchesia and I am counsel appearing on behalf of the defense. And if this court grants me latitude, then I will move to address this court in 10 minutes on whether there are reasonable grounds to believe that my client is criminally responsible for genocide under Article 28 of the Rome Statute. Your Honors, the specific question at which issue number 3 seeks to litigate is whether the glove of command responsibility fits my client, Mr. Gravers. With regards to this, defense will argue, one, that Mr. Gravas lacked both strands of knowledge. And with relation to this, Your Honors, we shall guide this court through the happenings in Luz and Cecil, as well as Luz and Luzari. And secondly, Your Honors, defense will argue that Mr. Gravas lacked effective control owing to the fact that his orders were not complied with and his chain of command was weak and indeed malfunctioning. Your Honors, then permit me to begin with the issue on knowledge. It will be nearly impossible for even the best of doctors to prescribe treatment for an illness without knowing about the disease in the first instance. And Your Honors, make no mistake, Mr. Gravas is no different. For him to exercise his effective control, for him to be able to try and take reasonable and necessary measures, he at least needed to have known about the crimes that were ongoing in Castiria. Your Honors, paragraph 430 of the Bemba Pretrial Chamber 3 decision is quite specific with regards to actual knowledge, that actual knowledge cannot be presumed and must in fact be proven. It is our submission that the OTP has not proven that this actual knowledge in fact existed, and it is not sufficient for them to claim that the information was available. The question under actual knowledge is, did Mr. Gravas know? It is our respectful submission that Mr. Gravas did not in fact know. Your Honors, moving on to the standard of should have known, the standard, and I see Judge Nicolai perhaps has a question.
No, please proceed. Thank you.
Thank you, Your Honor. It is our submission that once a commander receives knowledge, putting him on the notice of a real and reasonable risk of commission of crimes, they therefore have the duty and obligation to undertake measures to secure knowledge. The first counsel for the prosecution has submitted that owing to the constant communication between Mr. Gravas and Mrs. Jolie, he ought to have known about the commission of these crimes. They have also submitted that these crimes were committed over a specific period of time, and therefore he needed to have had this knowledge. And lastly, Your Honors, they have also submitted that the international community pointed out the events, and therefore Mr. Gravas ought to have known. It is our submission that we beg to differ with that preposition. And to negate this, Your Honors, we shall guide this court through the sources of information in Luz and Luzari, as well as in Luz and Cecil. It is our submission in Luz and Luzari that Mr. X formed the primary basis of the IHRD reports. However, Your Honor, please note with caution that this information was in fact singular, anonymous hearsay evidence, and most importantly, refuted by Mr. Gravas's reporting mechanisms. If you move with me to Exhibit 1, we see the communication between Mr. Gravas and his trusted head of NDS, Mrs. Jolie, as well as, Your Honors, in paragraph 12, if you move with me there, we see that Mr. Bryan, the head of police, completely rejects what the IHRD report states, and if in fact refutes the claims made by Mr. X. It is our submission that this automatically contradicted the information given by Mr. X and the IHRD. Your Honors, the legal test is that in paragraph 43 of the Bemba appeals judgment in the joint concurring opinion of Judge Christine and Judge Morrison, where it is in fact acknowledged that if a commander has genuine reason to doubt the veracity and accuracy of the sources of information, then it may absolve him from knowledge. And it is our submission that, Your Honors, even if you were Mr. Gravas, confronted with the anonymous hearsay evidence of one unknown Mr. X vis-a-vis that of your trusted head of NDS, Mrs. Jolie, it is our submission that the most viable option will be to go with that of Mrs. Jolie. You're not moving on to Luz and Cecil.
Counsel, I do have a question now. You're relying very much on the text exchange between Mr. Gravas and Mrs. Jolie. Isn't it also possible to assume that having a single text message exchange would not be sufficient in light of an international outrage, including European Union and ICC states parties?
Thank you, Your Honor. And in fact, we acknowledge your concern. However, Your Honors, if you move with me to paragraph 12 as well, we see Mr. Bryan completely refuting the IHRD claims and showing that as a matter of fact, they are going pursuant to Mr. Graves's orders. And therefore, there was no notice of a real and reasonable crimes being committed in Castiria. And which then leads me to the international happenings. Your Honor, please note with caution that the social media pictures form the basis of the information by the European Union, as well as the ICC state parties, as well as the international journalists. And therefore, to that extent, we do concede that this puts him on the notice of a real and reasonable risk that a famine occurred in Castiria, and not that there were crimes being committed. And therefore, Your Honors, it is in fact why Mr. Graves called this a conspiracy, because the outcome, which was the famine, was as a result of the deteriorating economy and not owing to the fact that he reasonably believed that a crime was being committed. Your Honor, please do not turn a blind eye to the fact that my client was deliberately misled and no further reporting was in fact seen pursuant to the fact sheet. It is our submission that the only guide for this court is that as seen in paragraph 432 of the Bemba Pretrial Chamber 3 decision, that it is in fact possible for a commander to exercise due diligence and inquire, but still fail to get necessary information, and therefore he cannot be blamed. And therefore, Your Honors, we ask that the court finds that the only reasonable conclusion is that he does not satisfy the knowledge standard under Article 28. Your Honors, moving on to effective authority and control, it is our submission that the question that the court seeks to litigate is whether, to an objective observer, Mr. Graves possessed the material ability to control or repress the forces. Your Honors, lest we forget that Mr. Graves is a man deceived by those closest in his command chain and eventually overthrown. The question then becomes, how then could he possess effective control? The second counsel for the prosecutor has erroneously submitted that owing to the fact that he was president, he ought to have had effective authority and control. However, Your Honors, the first issue of contention in the Hadzi Hasanovich appeal is in fact the question of formality of titles. Please note that being a president is only the formality of titles and does not ascribe as to whether one had effective control. And in fact, Your Honor, in the separate opinion in the Bemba appeals decision by Judge Ebo Osuji, it is in fact stated that sometimes power may not always be in the hands of those who are entitled to have it, and therefore it is important to prove effective control. And therefore, Your Honors, please do not be swayed to look at only the formality of titles and look that Mr. Graves is a man that was eventually overthrown. And in the unlikely event that the court is not convinced by this argument, we would like to rebut this presumption pursuant to paragraph 190 of the Bemba Trial Chamber 3 decision. An indicator of lack of effective control: one, there is non-compliance to orders and the existence of a weak and malfunctioning chain of command. Your Honor, it is our submission that with regards to non-compliance to orders, there is a major distinction between my client's orders and what the rogue forces went on to do. If you move with me quickly to look at the conduct of the forces, in paragraph 13, we see the kicking of pregnant women on the stomach. The question then becomes, Your Honors, is this part of the CNF terrorists as Mr. Graves had asked in paragraph 11? And secondly, was this the most necessary means as Mr. Graves had asked in paragraph 11? Your Honor, paragraph 14 as well in the last line shows that they were capturing women aged 13 to 24 and in fact raping them. It is similar to the facts in Prosecutor versus Hadzi Hasanovich in paragraph 226, where we see that there was the abduction of women contrary to the orders given by Mr. Hadzi Hasanovich by the El Mujahideen forces. And Your Honors, might I add that the court ruled that this was an indicator of lack of effective control. Your Honors, we have already submitted on a weak and malfunctioning chain of command by stipulating that as a matter of fact, the forces were in fact busy deceiving Mr. Graves. It is our respectful submission that this is a classic case of what Judge Ebo Osuji termed as a situation of complete loss of control. Your Honors, with regards to the command responsibility glove, it does not fit my client. Thank you.
Thank you, Counselor. Are there any questions from the panel? Then we can move to any rebuttal from the prosecution if you have.
Yes, Madam President. Madam President, Your Honors, in response to the arguments established by the Defense Counsel, the OTP will have the following points. First, we would like to restate and highlight that the evidentiary standard in the present case is reasonable grounds. This does not require an absolute certainty. It only requires the existence of a reasonable conclusion. As this court also confirmed in its decision concerning the situation on initiation of investigation in the territory of Kenya, reasonable grounds test has the lowest threshold when compared with other evidentiary standards. Second, Your Honors, the Defense Counsel conceded that the burden of proof in inadmissibility lies with them. Since the Kenya admissibility decision in paragraph 61 specifies that the evidentiary standard in demonstrating the willingness and ability to conduct an investigation and its genuineness is, and I quote, evidence of a sufficient degree of specificity and probative value, end of quote. The defense failed to demonstrate that the case is admissible. And regarding this, we would like to highlight a crucial point. The case facts does not include any fact or evidence, which shows that the military court started the investigation. The mere fact that the military court was established is not sufficient to claim that it started investigations. Third, the Defense Counsel argued that the target was the CNF terrorists and their Castrian supporters. But we would like to highlight paragraph 12 of the case facts. On that night, the security forces killed 200 Castrian men, but only 2 of them were CNF members. Now, we would like to ask the Defense Counsel, how can they argue that the main target was the CNF terrorists, but not the Castrians? Fourth, the learned opposing counsel seems to be confused about who has to have the genocidal intent. The present case is one of command responsibility for genocide under Article 28 of the Rome Statute. The defense's arguments on specific intent concerns individual criminal responsibility of perpetrators under Article 25. As confirmed in the Blagojevic and Jokic judgment, specific intent of the subordinates shall be demonstrated for subject matter jurisdiction as we submitted in our main pleadings. Lastly, we would like to remind the position of Mr. Gravus in Republic of Anatun. He was not a mere ordinary man. He was the president and commander-in-chief who controlled the armed and security forces and all 3 branches of the government. This court shall put an end to impunity for the perpetrators of the crime of genocide and prevent such atrocities from happening in the future. As the enforcers of criminal justice, we, the OTP and this court, must ensure that the ones who are responsible are brought to justice and victims receive reparation. Unless I have further assistance, this concludes our submission. Thank you.
No questions from the panel. We can see if there's any rejoinder from the defense.
Yeah, I just have one question, counsel. Ultimately, do you have to prove that the defendant had genocidal intent, specific intent or not?
Your Honors, in the present case, as we submitted, we have to prove the specific intent of the security forces who are the perpetrators in the present case, because we are invoking Article 28, superior responsibility or command responsibility in another name for Mr. Gravus's responsibility. In the present case, we are not required to demonstrate specific intent of Mr. Gravus.
Thank you, counsel.
Thank you, Your Honors.
Thank you. All defense, you have the floor for any rejoinder.
Thank you, Your Honor. defense acknowledges that many things have indeed gone wrong in Castiria over the past few months and years. However, a predetermined and preemptive conclusion by the Office of the Prosecution that the Castilian military court will eventually fail is indeed unjustified, unfair, and unjust. To that end, Your Honors, defense will reiterate three major submissions when you retire, because much has been said, but when you retire to make a decision, we ask this court to deliberate on three major questions. The first one, Your Honor, is on the issue on admissibility. And we have rightly stated that the burden of proof lies with us in this instance. However, Your Honor, the main question would therefore be, what does our holy book, which is the Rome Statute in this instance, say about admissibility? For this answer, Your Honors, look no further than paragraph 10 of the preamble of the Rome Statute, as well as Article 17 of the Rome Statute. Take that and juxtapose it to paragraph 17 and 18 of the fact sheet. It is our invitation that you may find that the military court is in fact well, willing, and able. And Your Honors, on the issue of specificity, as has been alluded to by learned counsel, it is our submission that it cannot get as specific as what presiding Judge Marie referred to as the deadline being August of 22. And therefore, Your Honors, it cannot get as specific as that in terms of the investigations in Castilia. And therefore, our invitation to you is to find that the military court can in fact carry out proceedings and let them pronounce themselves on this matter. Your Honor, second of all, which is on jurisdiction, we do submit that subject matter jurisdiction has in fact been contested by the defense. The question therefore becomes, what is the litmus test for a finding of genocide or lack of genocide? And as rightly asked by Judge Roger, it is important for us to prove, and Your Honors, issue number 3 is quite specific, command responsibility for genocide. And therefore, Your Honors, we cannot evade from the question of specific intent with regards to Mr. Gravus. It is our respectful submission that without specific intent to destroy a protected group, then it cannot qualify to be genocide. And Your Honors, this is not my dictum, but that of the ICTY case of Prosecutor versus Kamuhanda in paragraph 622, as well as the case of Prosecutor versus Clement Kaishema. And lastly, Your Honors, this last matter you need to ask yourself is on command responsibility for genocide. Your Honors, have the chapeau requirements under Article 28 been fulfilled? It is our respectful submission that these requirements have not been fulfilled. We have negated effective authority and control. We have negated the standard of knowledge that Mr. Gravas had, and therefore the glove of command responsibility does not fit Mr. Gravas. We indeed acknowledge that there has been undeniable suffering on the part of the Castilian victims. However, Your Honors, it must not be forgotten that international criminal law is concerned with criminal responsibility and culpability and not socio-historical wrongs. And therefore, Your Honors, please decline the OTP's invitation and deliver justice where justice is due. If there are no further questions from the bench, defense would like to rest their case. Thank you.
Thank you. Panel? Then that concludes the hearing today, at least as far as the submission. So thank you to both of the parties. We'll now take a petite pause and deliberate with the bench and return as soon as we can. Okay, I think everyone is here. Someone stop me if you're not, if we're missing anyone. I just want to say from my side, congratulations to making it this far, and congratulations on today's submission and well-thought arguments. It was clear that you put a lot of time and energy, even from last week, into crafting where you are today, the positions and the submissions that you have put to us, and given us a very difficult task of evaluating which team maybe came out in this round just a little bit above the other one. Before we get to that moment, I want to give the floor to my fellow judges for a little bit of feedback, maybe for future sessions, or just to quell any curiosity about how or what our thoughts were on this. So let me hand over to Judge Bülte.
Thank you, Madam President, and thank you to both teams for the submissions, which were quite good. It was very fun to listen to you because it was quite good. It was quite, you were performing on quite a high level, we think. So it was really good. And in terms of use of facts, that was excellent. In terms of the use of the law as well as legal authorities, very well done, both teams. In particular, it was good to see the rebuttal and the surrebuttal, because that's where you go off script and improvise and see what the other team has thrown at you and you throw things back. And that you did quite well, and we believe that the defense especially changed their main submission a bit, even in order to react to what the prosecution had to say. So this was very well done and quite impressively done. Thank you very much.
Judge Clark.
Sorry, a little trouble unmuting there. Look, that was a very exciting argument. In fact, it was a very professional argument. I've heard real people argue in real courts nowhere near your level of ability in coping with the facts and the law. And as I enjoyed the argument very much. Ms. Karsu, I would like to congratulate you on the way you used the elements of crime. We all have a bee in our bonnets about some things, and it seems to me really important that those elements get used, and you used them in the spirit and letter of them in a very nice way. So I would like to congratulate you on that. But look, all of you did some really exciting advocacy, and I hope this has been an enormously good experience for you. One of the awful things about being selected as a judge, which is not something I normally do in my life, is you have to decide at the end of the day and try and agree with your colleagues and so on. We were agreed on the result, but it was a very close case. And thank you so much for a fun way to start my day in Philadelphia here. Thank you.
Thank you. I can only underline all of the comments of the judges. This was a particularly fun, lively round to listen to you all. And going forward into next rounds, in the future, in careers, the only thing maybe I would say, because you nailed the responsiveness, you nailed pace, tone, argument, was all fabulous today, is maybe just to look over the arguments one more time, just to make sure you're pulling out what is the core, leave anything else that's there's still a dead weight, and using any of your time to make sure that it's strongest. And also just triple check for any sort of internal consistencies, any landmines you might step on that then could negate other really good reasoning that you've had. Just go over it again and again, which you've been doing for months now, probably. So without further ado, I cannot agree more with Judge Clark that this is probably the most difficult part to pick a winning team, because this was a hair as far as how close this round was today. But as we can only have one winning team, we would like to announce that the winning team of this round is the prosecution. Going further than that, we can also give the first best speaker and the second best speaker of the round. I'm happy to announce those as well. First best speaker of the round is the second prosecution speaker, Ms. Karsu. And the second best speaker of this round is the second defense speaker, Mr. Shami. So I want to say thank you very much for all of the time and an effort and your submissions and your energy. And I'm really looking forward to see you all go further in next rounds and careers. So best of luck.
Madam President, Your Honors, we would like to thank you for judging this match, and we would like to thank you for your valuable feedback. Also, we would like to congratulate team number 11. That was a really great match for us. Thank you.
Thank you very much to everyone too, and we wish you all the best in the future. See you soon.
Thank you to everyone and to the organizers, to our bench clerk.
The International Criminal Court is now adjourned.